Good afternoon for the eastern part of the country. Western, good morning. My name is Jamie Barnett. I'm a partner here at the law firm of Venable LLP in Washington, D.C., co-chair of the telecommunications group. And we'd like to welcome you to our webinar on the NIST Cybersecurity Framework, what you need to know. We're going to limit this to an hour of good discussion. We've got some great folks to talk to you about this. We really appreciate your time in being here. Welcome to the members of the press who have signed on. We appreciate you as well. We are, let me make sure if I can make sure this advances. Okay, we do that. Great, thanks. This is our agenda for this afternoon. We'll be talking about some of the overview, analysis, and then the privacy aspect. We'll take your questions. The phone lines are muted, so the way that you ask questions will be to, and you can do this at any time, on the chat function. I do want to let you know that the program is being recorded, and the recording and the slides will be available later this afternoon from our website, and we can provide information to you about that. This is our lineup today. I'll be making some brief remarks on this, but Jason Wool focuses on our electrical and other utility regulation. He's been at every one of the NIST workshops on this and has participated fully in those, and we'll be giving you an overview. Stu Inges actually will probably not be with us today. It's been delayed, but we have Ariel Wolf who will be filling in for him. If Stu comes in, we'll maybe let him say something about privacy at the end. And then our headliner today, we're very pleased to have Larry Clinton, the President and CEO of Internet Security Alliance. He's been a great friend and has done tremendous work with his trade association, multi-sector trade association. Look at his website and see who the members are there across several industries. Several articles, testified in front of Congress, has a tremendous resume both on the Hill and in the telecom industry. And Larry, we look forward to hearing from you. So we're looking at this new framework, a year in the making, initiated in February of last year with Executive Order 13636 and really its Common Traveler Presidential Policy Directive 21. And now that it's out, how will this affect you and your companies? And looking at what the implications are. Certainly, the cybersecurity framework is a signal achievement of a government-initiated, industry-led collaborative project for basically voluntary best practices. I do believe that it will have a national impact, and we'll examine today, what that impact will be. I would say that the cybersecurity framework is the most that can be done without legislation, but I personally wouldn't want anyone to think that with this program addresses all that should be done. There are definitely limitations to it, but it is a signal achievement. So what are the impacts? We will be discussing, whether or not this could actually affect a new standard of care in the courts. And we do think that there will be an impact, particularly for the companies that do business with the federal government. Certainly, our attorneys at Venable that do a lot of government contracting type work are looking at what will happen when the RFPs and various other advertisements the government puts out, how that will be incorporated. We certainly expect that we'll do it. So, this is voluntary. There are incentives involved, but for those companies who have already been doing business with the federal government, that may be a carrot where you're kind of getting hit over the head with a carrot. It's something that you'd have to do to be able to continue to do it. And for regulated industries, there is a potential for regulation, although you'll hear us also talk about the fact that the White House has articulated they're not looking to expand regulations except to bring it in line with the framework. So clearly now the focus shifts to adoption. There are not strong mechanisms for measuring adoption at this point. That still has to emerge. But you are seeing companies, particularly companies that were involved in the framework, lining up to say, we are promoting adoption, we want to see this, and I'm sure that one of the motivations for that is to stave off any regulatory action. one of the questions will be, are these incentives enough? And in my personal opinion, legislation is still needed to provide particular incentives to make sure that it is widespread and it develops quickly. But that's one of the things that we wanted to have this for, to have that discussion. And so at this point, what I would ask is that Jason will take it over and go through kind of the basics of what the cybersecurity framework is and what it does.
Sure. Thanks, Jamie. You can go on to the next slide. Okay, great. I guess just to put the framework in context, the first thing that we'll review is the executive order that now was issued a little more than a year ago. Executive Order 13636, Improving Critical Infrastructure Cybersecurity. Just as a reminder, Section 7A directed NIST to develop a cybersecurity framework, which is what they produced a year later, after a series of workshops, a preliminary framework, and some other drafts and commenting periods. Next, the Department of Homeland Security was directed to establish a voluntary program to support adoption of the framework. And they were also, through that program, directed to establish a set of incentives to promote participation. The final framework was released exactly a year later, on February 12, 2014. On the very same day, the DHS voluntary program, which they're calling C-Cubed, or Critical Infrastructure Cyber Community, was launched. And NIST made clear that this was just version 1.0. It was going to be a living document, and that NIST would be the convener for at least the next revision, and then hopefully they've said that they'd like to hand it off to a non-governmental organization or a private association of some kind, but we don't know what that would look like yet. To give you an overview of the basics of the cybersecurity framework, it really hasn't changed very radically from the previous draft, which you may have seen. It still uses the 5 core functions: identify, protect, detect, respond, and recover. Those are further divided into categories and subcategories, which then point you to what are called informative references, which leverage existing cybersecurity best practices. NIST used the same, for the most part, group of sort of standard or most popular cybersecurity standards, such as ISO 27000, SP 853, which is a NIST publication, COBIT 5, ISA 99, etc. The framework also retained the use of tiers and profiles, although one criticism that I have as of now, which is one of the few that I have in terms of the final product, is that the connection between tiers and profiles is not particularly clear to me. In previous drafts, profiles, which are defined in the framework as the alignment of the functions, categories, and subcategories with the business requirements, risk tolerance, and resources of the organization. A profile was previously defined as the set of tiers that an organization applied to its cybersecurity program. Now there isn't an explicit connection with tiers. Tiers are also described, I should mention, as the degree to which an organization's cybersecurity risk management practices exhibit the characteristics defined in the framework. They say that NIST explicitly writes that it is not an expression of maturity, although if you read them, they seem very much like an expression of maturity. I'm sure that was something that they had to put in there to win, the buy-in of certain stakeholders.
And I think they did not want it to be a maturity model.
Right. It's not a maturity model, but the tiers do seem to express levels of sophistication of risk management. But in one of the additions to the framework that I think were very beneficial, NIST, in emphasizing flexibility, made clear that there's no obligation to move up the chain of tiers from 1 to 4. They do encourage, if you are at 1, to move up to the next level, but there is no obligation to do so, and we'll touch on that as well. So other changes from the preliminary version. The most notable, which my colleague Ariel will touch on, is the removal of the separate privacy appendix and the integration of a privacy methodology into the body of the framework at Section 3.5. There's also an increased focus on what we're calling C-suite language or MBA-type language, sort of language that was put in to explicitly appeal to executive management to win their buy-in and get them to participate in risk management in a cybersecurity context. There's also increased focus on flexibility to, I think, emphasize the voluntary nature of the framework. We'll touch on that in a little bit as well. And there were some tweaks made to the specific controls that were mentioned in the framework. A couple that I noticed right off the bat. There used to be one that said that addressed the protection of intellectual property. It didn't really seem to fit in the critical infrastructure context. There's also removal of an explicit reference to PII. I think Ariel will touch on that as well. There was an addition, for instance, of language on network segregation in the access control subcategory that I found notable. Those are just a couple examples. So I think the big question, which Jamie initially raised, is what's the impact of this framework going to be on business? I think that the implementation of the framework is clear from the final version, is left to the entity's discretion. And what I mean by implementation is the specific way that an organization chooses to put in place the framework or use the framework in their particular organization. I made a little catalog of some of the remarks on flexibility that are in the final framework that I think really hammer this point in. Right off the bat, they say, through the use of profiles, the framework will help the organization align its cybersecurity activities with its business requirements, risk tolerances, and resources. The framework focuses on using business drivers to guide cybersecurity activities and considering cybersecurity risks as part of the organization's risk management processes. The framework is not a one-size-fits-all approach to managing cybersecurity risk for critical infrastructure. Organizations will continue to have unique risks, different threats, different vulnerabilities, different risk tolerances, and how they implement the practices in the framework will vary. Those are just a few examples of the, I think, new or at least slightly more emphasized flexibility of the framework. And again, that's probably to ensure greater buy-in of the framework among private businesses. But at the same time as flexibility has been emphasized, it's also clear from a few statements that there are some expectations on NIST's and the federal government's part. For instance, they say organizations responsible for critical infrastructure need to have a consistent and iterative approach to identifying, assessing, and managing cybersecurity risk. They also say that in performing a self-assessment using the framework that an organization may determine that it has opportunities to or needs to improve. So I think that these are expressions of some sort of minimum expectations of risk management on the part of critical infrastructure owners and operators. There's also, I think the bottom line here is that security concerns have to be managed in a manner that is commensurate with risk. That doesn't mean, and this is going to touch on the slide down the way on liability concerns, but this minimum expectation of risk management is not necessarily a prescription or a standard of care, but it is an expectation at the very least that risk is managed appropriately. And we'll touch on that in just another slide. So incentives, which is something that I believe Larry will talk about in greater depth. As mentioned, the C cubed is the DHS program that is responsible for incentivizing participation and adoption of the framework. For right now, technical assistance is all there is, and we've known this for a while that technical assistance would be the only initially available incentive. In terms of financial incentives, I think that the general consensus is that the federal government is working on incentives, but there doesn't seem to be anything coming down the pike anytime soon. And in terms of financial incentives in particular, it doesn't seem like there's anything coming down the pike, especially without legislation. What they've mentioned is public recognition, rate recovery for regulated industries such as in electric industry, grant requirements, and actually that's not really an incentive, it would be a requirement to get a grant, would be that you put it in place, so it's a carrot stick, as Jamie would call it.
To get hit over the head with a carrot.
And regulatory streamlining or harmonization. So because there aren't any tax incentives on the table, because liability protection would require legislation, and I think because industry has expressed that the incentives that have been discussed aren't necessarily the most attractive to them, I think we've heard DHS and the White House say that safety is the biggest incentive for adoption, and I think that that makes sense from a public well-being perspective. I'm not sure that businesses, who are have a fiduciary duty to their bottom line and all that they're going to be as attracted by the safety as its own incentive argument. But that said, it's absolutely true that the protection of critical infrastructure is a good in itself. The federal government has also said that their expectation is that market-based incentives will develop organically, and that those are going to be the financial incentives that businesses are looking for. Those include better access to insurance, and perhaps something like a trust mark type certification for companies that put this in place. That raises questions, I think, of what adoption is, though. Would there be some sort of auditing expectation or conformity assessment, as NIST likes to call it? And then just one other thing to talk about on incentives is the idea that legislation would be needed to expand the availability of liability protections. I think liability protection is the number one incentive that businesses are looking to in exchange for participating in the program on a formal level. I think that many organizations are planning to use the framework, maybe in an informal capacity. And when it comes to formal participation or formal adoption, putting the business's name out there as using the framework, that liability protection or limitation is one of the most attractive options for moving in that direction. The Safety Act is something that we often talk about as being a currently available tool for liability limitation or even limitation. If you're not familiar with the Safety Act, I don't want to take too much time on it here, but it's a statute that essentially can limit or eliminate civil liability for acts of terrorism arising out of acts of terrorism where an entity, a business, has deployed or implemented what's called a qualified anti-terrorism technology. And I should also mention that there is a bill going through Congress right now. The House Homeland Security Committee has approved it, that would expand the Safety Act. It's called the National Cybersecurity and Critical Infrastructure Protection Act of 2013. It would amend the Safety Act. One of the things it would do is amend the Safety Act to also cover a qualifying cyber incident. Again, we don't want to take too much time to talk about that here. You can always email with questions, etc. If you want to learn more about that and what the potential impact could be. But that's just one example of a legislative goal that would really dovetail well with the framework. So liability concerns. We've touched on this a bit. Some people have identified the potential for a standard of care for emerging tort liability arising out of commercially unreasonable cybersecurity practices, sort of with an eye towards the framework or using the framework as the standard itself. I think that with the newfound emphasis on flexibility, or with not newfound, but with the more emphatic expression of flexibility in the framework, I don't see the framework as a standard of care. I don't see liability arising out of the fact that a breach occurred and an entity hadn't implemented every single control in the framework. I think that the key is risk management, as I mentioned previously. That is assessing organizational risk in the cyber context and having a reasoned and well-documented response to that risk in terms of how to mitigate it, accept it if necessary, And that's really what I think is the key. If you haven't performed a risk analysis, if you haven't documented it, there you're going to be in trouble. But if you have at least gone through the process and have a reasoned defense for why you made certain decisions, why you chose not to implement certain of the controls, I think that is the expectation. Again, the framework says over and over that every entity has its own needs and interests. Business drivers are going to be one of the main inputs into this risk assessment, and that's the important thing. That said, critical infrastructure by definition is high impact. It's likely to be held to a more stringent standard because of the inherent risk that goes with owning and operating critical infrastructure. So I think that's a consideration. I also think that corporate boards who already have responsibility for risk oversight, now need to be extra careful to integrate cybersecurity risk management into the sets of topics that they review on their audit committees and whatnot. And I think that's one of the main takeaways. Just that the risk management, it was already a requirement, but risk management is now absolutely upfront in the cybersecurity context. That's pretty much the end of my notes. The last slide is just a series of questions about what's coming up, what's coming down the pike. These are questions that even though the framework has been released, haven't been answered yet. What does adoption look like? That's something that could be raised in the C-cubed context. It's something that could affect the use of those trustmark-like certifications. And also if in the future attractive incentives are put forth by the federal government, how to qualify for those and continue to maintain those incentives. How will insurers make use of the framework? Supposedly there's going to be a request for information on this topic, but it's a little unclear what that, quote, incentive will look like in combination with the framework. And then just as we've mentioned, the availability of quality incentives. Will there be quality incentives that are at least federally backed, and will those spur adoption? And that's the end of my remarks. Larry, should I bring this over to you?
Yeah. Jason, thanks so much. And so, once again, for those of you who may have tuned in a little bit later, we're very pleased to have Larry Clinton, the President and CEO of the Internet Security Alliance, with us. I guess you could provide the colored commentary, the analysis of what's going on. And Larry, if I could mention one thing from his resume that I may not have mentioned before, led the many members of the Internet Security Alliance in developing the cybersecurity social contract, which I think has also informed the debate on this. So, Larry, thanks for being with us.
Thank you, Jamie, and thank you, everybody. I do have some slides that I'll be going through. I rewrote my remarks last night after I'd sent Jamie the slides, so they may be a little bit inconsistent, but they generally follow along. And if anybody wants the actual text, I'll be reading from it. I'll send the text over to Jamie, and people can contact me directly. In 2008, ISA published the Cybersecurity Social Contract, which suggested that the appropriate public policy would be for government to work with industry to collect effective standards and practices and urge voluntary adoption of these through the use of market incentives. So we were naturally delighted when last year the President issued an executive order that instructed NIST to work with industry to organize a framework of standards and practices that industry would voluntarily adopt through the use of and deployment of market incentives. And last week I was honored to be with Jamie and Jason at the White House for the unveiling of the framework. So what do we think of all this? Well, ISA's view is that the entire program under the executive order, not just the NIST framework, but the call for the development of the incentives, the new National Infrastructure Protection Plan, which, by the way, for the first time, recognizes that industry and government have aligned but legitimately different ways to analyze cyber risk, and that the commercial level of security is different than the national level of security. These are all groundbreaking and extremely positive approaches to the massive and growing problem of cybersecurity we face. We hope that this is the model that will become the precedent for the world that is far more progressive than, for example, what they are considering in Europe. As pleased and hopeful as we are with respect to the executive order, the framework is not the answer to our cybersecurity problem. It's just a step in the right direction. And to be clear, The administration is not claiming that it's the answer to their problem, but we have already heard some in Congress and the states assert that all we need to do now is to codify the framework. That would be a mistake. But it does get to the larger question of how do we get people to actually use the framework. At the White House last Wednesday, Lisa Monaco from the National Security Council put it succinctly. The key now is use, adoption. Adoption of the framework is how we're going to measure success. And Ms. Monaco is exactly correct. As much as we like the model and the progress to date, we need to be very clear that a lot more needs to be done. To put it in Olympic terms, we've survived the preliminaries, and now we're going to go on to the medal round. And just like in the Olympics, the competition gets harder as you go on. And make no mistake, cybersecurity actually is a competition. Cybersecurity is not really like consumer product safety, where the issue is faulty design or cheap manufacture. It's not so much that we have a bad cyber equipment problem, so much as the cyber equipment is under constant attack, and the attack team is getting better and better all the time. A few years ago, we began to see very sophisticated nation-state cyber attacks, which were dubbed the APT for the Advanced Persistent Threat. These APT attacks were mostly against defense establishment and were so sophisticated that they would compromise all perimeter defense. Firewalls, passwords, intrusion detection, antivirus, all useless. These attacks were characterized by the strategic use of reconnaissance, multiple methods, staged incursions, a high degree of stealth, and they invariably succeed in compromising the target system. While these sophisticated attacks were confined to the defense industrial base originally, they have now been spread widely. Even the recent attacks on Target, which is not really part of our critical infrastructure, had many of these same sophisticated characteristics. Many of the standards and practices outlined in the framework will not be successful in preventing this sort of sophisticated attack. But the framework correctly calls for more than that. It asks for industry to use a risk management approach to cybersecurity. And that's a very good thing, but it too is not the complete answer. Because cybersecurity is not a binary. It's not be secure or not secure. For most companies, what risk management actually comes down to is a simple question. How much cybersecurity can I afford to buy? The core issue is economic, and the empirical research backs us up on this. The research done by such entities as PricewaterhouseCoopers, CIO Magazine, CSIS, and McAfee all show that the number one issue for cybersecurity and critical infrastructure is not the lack of standards, and it's not the lack of information. All the studies indicate that the number one problem is cost. As industry has been investing, by the way. Private sector spending in cybersecurity has doubled in the last 5 years to nearly $100 billion a year. Put that in context, the entire budget for the entire Department of Homeland Security is about $60 billion. That's for everything, immigration, FEMA, everything. We're spending $100 billion on cyber alone in the private sector. Nevertheless, when Secretary of Commerce Penny Pritzker asked AT&T CEO Randall Stephenson at the White House last Wednesday if he thought the smaller companies in their supply chain could afford the investment to keep up with the cyber threat, Mr. Stephenson told them flatly, no, they can't keep up. In fact, none of our companies can keep up. And I agree with Mr. Stephenson. One of the reasons why it's going to be so hard for the good guys to keep up with the bad guys is that the economic incentives in the digital world all favor the attacker. Cyber attacks are comparatively cheap, easy to access, initiate, and they're extremely profitable. By contrast, cyber defense is hard. You need to defend not just your system, but every system you interact with. In addition, getting adequate funding is hard because it's difficult to show return on investment for things that may have been prevented, and successful prosecution is virtually non-existent. Less than 1% of cyber attacks are successfully prosecuted. Moreover, profitability does not necessarily follow from increased security, regardless of what some have asserted. In fact, many digital investments that are required to keep companies competitive and profitable tend to weaken enterprise security. For example, you can't compete in most information technology markets unless you're manufacturing through a long international supply chain and they're virtually impossible to secure. You'll have a devil of time if you're going to try to recruit a young, savvy workforce unless you have a BYOD policy, bring your own device to work, which may lead your company to have your company's data on thousands of poorly secured phones and tablets. 2 years ago, PricewaterhouseCoopers did a study on cloud computing, and they found that 62% of IT professionals had, quote, little or no faith in the security of the cloud, including 48% who had already put their data in the cloud. Now, why would any reasonable executive make that decision? Because the cost considerations of adopting the less secure business process were overwhelming. So risk management, when you consider both the security and the economics, is not that easy. Now, the executive order, very wisely, had two elements to deal with these issues. The first was that the framework was supposed to be a cost-effective process. Now, I think that's an excellent feature in the executive order, because if we can show that the framework is actually cost-effective, industry will naturally want to adopt it without compulsion. Unfortunately, this is one aspect of the framework that is not well developed. Instead of providing a framework that's cost-effective, we have a framework where we're told to implement it in a cost-effective fashion. And I've just given several examples of how those decisions might turn out in the real world. Another excellent example of what's in the executive order would be that we need to address this through the use of economic incentives. If the framework is not, and this is good because if the framework is not demonstrably cost-effective, then at least if we have economic incentives, as the research has told us is the number one problem, we can mitigate these cost factors. Now, as Jamie mentioned before, ISA has written a great deal on the subject of incentives for cybersecurity, and we were appointed to lead all 16 sectors with regard to this through the development of the framework by the Partnership for Critical Infrastructure Security. And we have identified literally dozens of incentives that could be deployed to motivate increased cybersecurity. And being pragmatic about the issue, we have not focused on tax incentives, but liability incentives, procurement incentives, patent and permanent preferences, streamlined regulatory processes, forbearance, insurance, etc. It's important to note that these are incentives that we use throughout the rest of the economy. We simply haven't applied them to cybersecurity yet. Now, as Jason pointed out, the White House has announced that they will shortly provide a roadmap for developing these incentives, and we look forward to working for them. But as he pointed out at the moment, all we have is a comparatively limited form of technical assistance that DHS will offer to companies who are interested in implementing the framework. Now, there has been a fair amount of publicity about firms stepping up to say that they're going to use the framework, and again, we think that this is a good thing, but it's not necessarily news. The research has indicated that for years, as much as 50% of industries already use standards and best practices and standards, and they have been using them since long before the framework was ever created. In fact, a concern that some of the ISA members have expressed to me is that since they are already doing much more than the framework requires, they may face pressure from their boards to reduce spending under the assumption that the framework is all that's needed. So while it's true that IBM and AT&T and the members of the Internet Security Alliance are all using the framework, that's not the question. The real question is not how many people are using the framework on day one. It's how many who were not using it on day one are using it on day 101 or 301. That's our real target audience. And unless we address the economic issues, I'm worried about how much success we're going to have. The last point I'll make, and then I'll turn it over, is that we at ISA have proposed a path for moving forward on this. We think we ought to be considering the framework as having completed the design phase and now move into the testing phase. We propose that the government do with the framework what the private sector would do with any large-scale product or service it was rolling out. We beta test it. We're dubious of just letting voluntary feedback from early adopters, as they are most certainly not the real target group. Moreover, any statistician will tell you that voluntary self-report data is the most unreliable and invalid sort of data, and we ought not to be basing our national security decisions on the least reliable data. Instead, we need to develop metrics in the form of companies that are critical but are not otherwise inclined to adopt the framework. As DOE Assistant Secretary Poneman said at the White House last week, if we can't measure it, we can't manage it. And I'm not aware that we have any systematic program yet for developing reliable metrics around the framework. Our proposal would be to provide technical assistance on a voluntary basis, including incentives, to companies who we've already identified as having problems. We develop objective measures, monitor costs and rewards with the target group. At the conclusion, we would know what portions of the framework are and are not cost-effective and what incentives might be most useful, and that could be required to motivate elements of the framework that have high cost. In sum, we think the executive order is exactly the right policy and has tremendous potential, both for our nation and the world. However, we absolutely must include the economic aspects that have been proposed but not yet fulfilled. If we can do that, we believe that we can literally set the world standard for cybersecurity and do so in a realistically sustainable fashion. Thanks, Jamie.
Great. Larry, thank you so much for those insightful comments. Definitely, I think it's going to spur our discussion here. But I'll wait on that until we finish our last thing. So, as I mentioned to you earlier, by the way, we are starting to get questions in. You're free to go ahead and send your questions in using the chat function, and we will address that. Thank you, those who've already sent them in, and we will get to those at the end. If we can't get to them all, we will respond to them even after we leave the webinar. So next, with us filling in for Stu Ingus. Stu Ingus leads our privacy practice, nationally recognized privacy practice. He and Milo Subadanis, they couldn't be with us, but their right-hand guy is Ariel Wolf, who's going to look at some of the privacy aspects of this that Jason mentioned. And one that I guess would be one of the biggest changes between the draft and the final cybersecurity framework. So, Ariel, if you would take it now.
Thanks a lot, Jamie, and to everyone on the line. I think the easiest thing to do in running through the privacy aspects of the framework is to take a look at the evolution. As Jason mentioned, actually, everyone mentioned that the privacy methodology and is the component that has changed the most from start to finish. So looking at the origin of the privacy and civil liberties methodology, the executive order in the subpart of setting up the framework called for, noted that the framework shall include methodologies to protect individual privacy and civil liberties. Now, it's worth noting, just on the side, that there's also a call for the government to initiate its own review of privacy and civil liberties practices with respect to cybersecurity, and that mention something about that in just a bit. But so that was the call in the executive order. Now, the first take came in the preliminary cybersecurity framework, and what was presented in the preliminary framework was what came to be known as Appendix B, or was Appendix B to the framework. And what you saw there was a comprehensive privacy, data security, and civil liberties framework mapped to the framework core. And importantly, the introduction to Appendix B noted that the methodology was based on the Fair Information Practice Principles, a set of principles developed many years ago. And what Appendix B generated was a lot of concern amongst industry that the call in the executive order for the protection of individual privacy and civil liberties is being used as perhaps a way to develop a comprehensive privacy and data security and civil liberties framework in its own right, separate and apart from critical infrastructure and the protection of critical infrastructure for cybersecurity. So that was the concern. They were initiated a series of, well, there was a discussion between industry and NIST on a number of occasions, and there was a compromise document that was proposed. And so looking at what came out in the end in the final framework, generally what happened was Appendix B was removed, and a couple things were addressed. First off, I would say that going back and thinking about what the top industry concerns were. Number one, you had scope of application. Again, there was a concern that the title of the executive order was critical infrastructure cybersecurity, and the feeling was that any privacy and civil liberties methodology should be limited in scope to applying to the critical infrastructure sectors. And one of the proposals that was presented was to include language to the effect of that the privacy and civil liberties methodology does not extend or apply to commercial data activities. That language did not end up making it into the final framework. However, the concerns were addressed somewhat through language. If you look at Section 3.5 of the methodology of the framework, which is where the methodology was ultimately included in the how to use section. The way it's described and presented is this section describes the methodology to address individual privacy and civil liberties implications that may result from cybersecurity operations. So there's the concern was addressed somewhat. Now, there was hope that it would be limited to critical infrastructure, and parsing through that going forward, we'll see how that plays out. The other thing that changed was the Appendix B had a number of references to PII, or personally identifiable information, and that was a defined term in the preliminary framework. Those references were removed, and now what is used is the term personal information, which is not defined. This reflects the idea that in industry there's not really a consensus for this kind of term, and to the extent this is a voluntary framework that should be evolving, it would be appropriate to reflect the fact that that too is an evolving area. The other piece that I would mention is with respect to civil liberties. The primary concern that arose there was the idea that when we're talking about civil liberties, that's really a question of state action, something that applies to government protecting civil liberties. And so this is the private sector's cybersecurity framework. To what extent are civil liberties, the protection of civil liberties applicable to the private sector? And so what is present in the final version is a language to the effect of tying civil liberties, the protection of civil liberties, to the government or agents of the government, and that addressed those concerns as well. So, giving an overview there, I would just say that the content of the methodology to protect privacy and civil liberties, reflecting industry's proposal to some extent, rather than the comprehensive privacy methodology in Appendix B, which was 7 or 8 pages of tables mapped to the framework core and functions and categories and informative references to NIST documents and government documents, what you have now is it's been curtailed to focus on key areas where privacy and data security issues would arise. So, for example, governance of cybersecurity risk, and taking an overview or an assessment and access to organizational assets and systems, awareness and training measures, detection, and those are some of the areas that it was proposed that privacy and data security issues would arise. Going forward, I would just mention here, and then turn back over to the other presenters, just on this issue of the privacy engineering workshop. In the roadmap that was published by NIST accompanying the cybersecurity framework were a number of areas for consideration or improvement, I think was the name, and what was proposed there was NIST was going to convene a series of workshops, and one of them, which has been scheduled for April 9th and 10th, is going to address technical privacy standards. And the only thing to note here is the description on the roadmap of this workshop is broad enough in scope to give some concern that where there is concern in industry that initially with respect to the privacy and data security provisions, that this process of evolution going forward may result in an expansion closer to what was originally proposed. Now has not been presented that way, but that would be some area of concern to identify and to highlight, focusing on NIST's effort in the April privacy engineering workshop. So I'll pause there, and with respect to the future and direction of the framework, if others want to comment.
Great, Ariel, thank you so much. Appreciate that insight. So, I mean, from the first draft, so to say, to this, there was some modifying or softening of the privacy, but that still could come back. Huh?
Yeah, and I would mention it's a good point. I would mention that the process of industry presenting its proposal, it had a number of iterations. Venable and Stu and Milo were instrumental in trying to rewrite that and present it in final form to NIST, and ultimately was accepted again, mostly in the form it was presented.
Yeah. Right. Jason, anything on that or anything else?
No, I just realized that I skipped something that I had hoped to touch on slide 12, if you don't mind. Because this is an important point for the listeners. And that is, I think as most people know by now, the executive order in Section 10 directed the regulatory agents with oversight of critical infrastructure were directed in subpart B of Section 10 to determine if they determine that current regulatory requirements are deemed to be insufficient within 90 days of the publication of the final framework, which again, 90 days from February 12th, they were directed to identify or to propose prioritized, risk-based, efficient, and coordinated actions to mitigate cyber risk. So, Jamie, you mentioned rightly that at the White House press conference last week, they made clear once again that language right now means harmonization of regulatory requirements with the framework, not additional regulations or mandatory requirements. But obviously, the executive order is written in such a way that there is certainly room for mandatory regulations to be issued based on the framework. So I think that obviously we should take the White House at its word on this, but I would note that three examples come to mind right off the bat that I've read about in the news recently that sort of I could see making use of the framework in a way that is more than harmonization with existing requirements. The first one is I read recently about the SEC and its plans to perform examinations of asset managers and of their cybersecurity practices. That's an example of where the cybersecurity framework could be used as a baseline of some kind or used in their analysis. The second, FINRA examination letters were sent to securities firms with targeted examination letters about cybersecurity practices, and they, I believe, have enforcement authority. So that's another area where they're going to get this information. What are they going to do with that information? How are they going to analyze it? That's another area where you could see the framework being applied. And then finally, before the framework was released, the DoD GSA report that was issued, and Jim mentioned this as well, recommending that for acquisitions that present cyber risks, the government should only do business with organizations that meet baseline requirements in both their own operations and in the products and services they deliver. That's another area where you can see the framework being used. So again, I think I'm not at all calling into question the truthfulness of what the White House said and what they've repeatedly said about that Section 10 of the executive order, but I do think that there's a lot of wiggle room in that language and that you could see some agencies, even if they're not putting out requirements or new regulations based on the framework, using the framework in their existing capacities to gauge the cybersecurity activities of the entities that they regulate.
Right, so that's a good point. And for instance, I mean, I really do think that even though the framework is flexible, at some point I think you're going to see that being made more specific about what the government wants in government contracting. Mentioned the reporting, even though there's no way to measure this right now for those regulated industries, it's at least conceivable that at some point a regulatory body says, well, tell us how if you were implementing the framework, how you're implementing the framework. I mean, those kind of reporting possibilities. So I think it bears watching. I mean, so Larry, if I can, I'll have other questions that are coming in, but my question for you on this is, in some of the discussion that you had, I mean, a lot of the input that went into the framework, and it's a good framework because of the collaborative nature of its development, but these are a lot of industry groups and large corporations that have significant cybersecurity operations suggesting to the government what they already do.
Right. So
for the larger ones, I mean, is there going to be a lot of change in what they do? For the mid-sized companies, I mean, if you're not required to report, how are we going to know? And I think this is going to have national impact, but how much impact do you think this is going to have?
Well, as I tried to say in my remarks, we see the research which says that the number one problem is the economics of this. So if you're a large company with economies of scope and scale, able to, engage in a risk management process like this, that's great. But if you're and by the way, I wouldn't make the line large and small necessarily. I would say sophisticated versus unsophisticated, because there are a lot of smaller and mid-sized companies that are sophisticated in this. And frankly, there are some large ones that are not doing such a great job. But the number one problem is economic, and if we want to reach entities for whom they're in a competitive market and they've got all of these incentives to be less secure, to adopt long international supply chains and cloud models that aren't very secure, et cetera, we're going to have to modify that. The other thing, Jamie, that even if you want to do something on a voluntary basis that is not as developed in the framework as ISA and we would like to see, the framework's supposed to be prioritized, and it's really not from the way I put it. So if you're a good company and you want to look at the framework and you've got another $1 million to spend on security, which is a lot. Mm-hmm. The framework doesn't help you with where do you spend the $1 million. Do I update my software? Do I buy smartphones for all my employees so they don't use their own ones that are insecure? Do I bring my manufacturing back from overseas to the U.S. and pay a little bit more for that? Do I hire a good public relations firm because in terms of the reputational risk, what the research indicates is that cyber events don't have a reputational risk. It's publicity about cyber events that causes the reputational risk. So maybe you mitigate your risk by hiring a better PR firm. So there's all sorts of places to spend that marginal dollar. What's going to get the most marginal dollar out of it, which is why we say we need to take what we have now, which is good, and do a study with it. Find out, get real metrics from the real target audience, figure out what within these various classes is most cost effective for them, and when there are things that maybe are useful for national security but not cost effective for a smaller organization, then we supply them with some sort of incentive to mitigate that cost.
Right, so the work starts here.
Yeah.
Well, it's sort of interesting, though. I mean, I think one of the reasons that they didn't put that in there is because they saw it as a threat to the flexibility and the scalability that is so important to them in terms of marketing the framework. But it's a really good point because, I mean, you see throughout the framework discussion of, use this risk assessment to figure out if you're over-investing in certain areas or if you're spending in the right ways. Prioritize how you emphasize your acquisitions when you have 20 things that need to get done. How do you figure that out? But it doesn't actually provide the guidance, and I think that kind of it dovetails well with the point that there also is no guidance on performing an actual risk assessment in here. It talks a lot about risk and the importance of risk management and risk assessments, but it doesn't tell you how to do it.
Which leaves it up to you. So from our audience, David Jordan, CIO in Arlington County, asked, the companies have now kind of been warned. They know what the challenges are out there, and if they've chosen an alternative to spending funds on cybersecurity, wouldn't this approach leave the company open to a class action suit or liability? So I'll include Larry in this, our not actually an attorney, but certainly someone who knows cyber legal, but also our attorneys in here. So in essence, you've got the framework out there now, and if you've chosen something else, I do think that actually if you have a documented program of going through the framework and making decisions based on the money you have, and people will not necessarily have $1 million, as Larry mentioned, but you've documented what your options were and why you did them, I think that puts you in better stead. I don't think the framework or any development of a standard of care is going to be strict liability by any means.
Sure, I agree.
But does it leave you open? Possibly.
Larry, do you want to go first?
Well, I mean, again, I'm not an attorney. See, everybody in the room knows this, but necessarily I haven't been on the call. I'm not an attorney, but it would seem to me that actually the framework works in the opposite direction. And that's not to say that a good plaintiff's attorney can't make a case. You can all make a case. But it's so easy. What adopting the framework or using the framework, complying with the framework, none of these terms are defined. So I think you could go in and say, well, we do, describe a fairly minimalistic risk management process and say, my legal obligation is to maximize shareholder value, under Sarbanes-Oxley. And so I maximized shareholder value, and I looked at my old system, and I compared it to the new system, and I made these decisions. I followed the framework. Sue me.
If you're showing that you've done something on the framework, then you can't be really said, well, I'm neglecting cybersecurity. So.
What do the lawyers think?
Well, I agree with Jamie. I think that it's all about the process of risk management, and there's on the one hand, if an entity is told explicitly that this is going to happen and with certainty, and they didn't do anything about it and could have, I think that's a potential liability. On the other hand, that's probably not always going to be the case. I mean, obviously there are going to be times when DHS contacts you and says, or the FBI contacts you and says, you've got a problem. But in most cases, you can't protect against everything. Companies know that, and they know that, there's no way to prevent all occurrences of hacking and breaches and security incidents. Sorry, I guess got a note. And I think that so the important thing is to make the right decision based on what the risk assessment that the company performs tells the company to do. And in fact, for boards where risk oversight and the management of risk is so important, the business judgment rule is what insulates boards and companies from liability when these types of things happen, provided that they have undergone a process of thoughtful decision making. And so, this is just another way. This is another, process that boards need to go through to document this risk management process in the context of cybersecurity. And I think if they've got that base covered, at least class action lawsuits. There always going to be class action lawsuits, but I think that there's going to be a better chance of dismissal.
So we're closing in on the end of our hour. We want to keep our listeners on schedule. One thing I'd like to mention is we will continue to have programs like this, and so stay tuned for those. I will be speaking at the RSA Cyber Conference out in San Francisco next week on communications, supply chain security. Did you have another question? Do we have time for another question?
Yeah, do we have time? There is one more.
No. Okay.
Do you want to do one more?
Yeah.
Okay, the question is, although you noted you do not believe the framework does not provide a standard of care, do you expect judges will uniformly share that view, or is it inevitable that in some courts it will be seen as a standard of care?
Well, so I don't think the framework itself will be the standard of care because it's a little bit too flexible, but I do think you could see plaintiffs, as Larry mentioned, bring it into court and questions going, well, what did you do on this part of the framework? What did you do on that part of the framework? And in essence, that could develop into a jurisprudence on that. And the thing about it, that'll develop slowly. It'll develop over a series of years. It'll be different in each state, in federal court, different circuits, things like that. It'll take a long time for that to develop. But could it be used that way? It is certainly possible to see it used that way.
Yeah.
Amy, if I could add just one other thing, and again, not an attorney, but I've been doing this for 15 years, and I've been hearing for 15 years that there are going to be these massive lawsuits, and that's going to drive increased cybersecurity. It hasn't happened yet. And one of the reasons that it seems to be is that locating where the liability lies is actually kind of hard. I mean, is it the operator who got hacked, or is it the software provider who had bad software, or has the hardware been compromised at some place that was unknowable? Was it an insider attack? Was it a nation-state attack? In which case, the liability is, it's unreasonable to prevent against. All of these things seem to make it kind of hard to bring these cases because.
Right. Easy to bring the cases, maybe
hard to win
the claim. So.
Well, yeah, that's true. But I think of, and this is the last thing I'll say. I swear. If you look at some of the 9/11 litigation, even before that, the World Trade Center bombing lawsuit. My recollection from the 9/11 litigation was that because of the high impact of the tower falling and just because if that were to happen, it would be so catastrophic. The opinion said something like, even though there's no way you could predict that a plane was going to hit the building, you should have known that if something hit the building or and it fell, that it would cause mass destruction. And I think that's what I really mean when I talk about that critical infrastructure has this sort of special equipment, because you know that if something happens there, it's gonna be big. And so I'm not saying that means that that a judge is going to find there's a standard of care, but I think that what a judge might say someday is, and this is not a reflection of the cybersecurity framework itself, but I could see a judge saying something like, because you knew how integral your computer systems were to the functioning of what you do as critical infrastructure, then I take issue with the decisions that were made in your risk management process. But that's not to say that this is the standard of care, because I don't think that this is.
Right, but wouldn't that be in the case of if you're having a 9/11, you're having skyscrapers fall. I might put that in a separate class than a judge somewhere determining in a commercial case that.
Yeah, certainly, yeah. Commercial is a different beast, but when we're talking critical infrastructure, sometimes we might be talking about like a nuclear plant that explodes or something, and a pipeline that explodes, and that's different than.
That is different
than your average data breach.
So some of that's still to be determined. Larry Clinton, Internet Security Alliance, thank you for this. Ariel Wolf, Jason Wool, the absent Stu Ingus, thank you, and for our staff here at Venable for their putting this on and get the word out. For all of you who tuned in, we certainly appreciate it. If you need more information or if we didn't get to your question, we have contact data here, and we're certainly glad to answer questions or chat with you on this. So we'll sign off right here, and thank you very much.
Thank you, Jamie.
Thank you, Jamie. Appreciate it.
Thank you. Please stand by.